Have a seat. Is Dylan coming back?
No.
Have a seat. It's 24 CV 52569, 25 CV 16784. State of Oregon, or excuse me, Jill Bong versus Douglas County School District 15. Here on a couple of different matters. Before I get started, my understanding is that we are here for motion to strike, or no, so forgive me, just a second. Motion for leave to serve additional requests for admissions, a motion to strike, disqualify, enter default, and impose sanctions, and I thought there was, motion for leave to serve additional requests for admissions. Is that the party's understanding of what we are dealing with here today? And then second question is, are there any outstanding matters that the court has yet to decide on from the party's perspective?
Your Honor, I believe it was to my understanding that today's hearing was for the proposed order dispute as well as leave to
For the protective order.
Yes.
Mr. Mergereau. Looks like you're either muted or we're having trouble hearing you for some reason.
I apologize, Your Honor. Can you hear me now?
Yep.
Okay. Yes, I believe it was also the form of order on plaintiff's motion to compel regarding those two subpoenas.
And which matter was that? Is that in 16784?
I believe so, Your Honor.
Yeah,
Yes,
I'm sorry. I'm just jumping back and forth here. All right, let's deal with that first. So what's the objection, Miss Bong?
Yes. The objection is undocumented counsel's proposed order improperly collapses the order and making it very vague. Firstly, the court found relevance to the subpoenaed documents, and the only limitation imposed was privilege and material beyond the scope of litigation. However, we've already established the existing relevance boundary, and it was not a new limitation, so therefore that's no longer in dispute. My proposed order reflects that ruling that the court granted.
So hang on, because I don't want to get lost in your argument. So the proposed order that I'm seeing says the subpoenaed parties are directed to produce documents that are, one, responsive to the subpoena received. Do you have any objection to that?
No.
Two, not privileged or subject to the work product doctrine. Any objection to that?
That requires a privilege log, because otherwise they would just say everything is work product.
A privilege log?
Something to say that, they're withholding it based on work product.
Okay. Mr. Merzero, do you want to respond to that?
Oregon law doesn't require a privilege log, Your Honor. This isn't federal court, it's state court.
It sounds like a federal. Yeah, that's exactly what it sounds like a federal law or a federal mechanism, and I don't think it applies in this case, Ms. Bong.
Okay, I'll submit my objections for appellate review on that.
Okay. And the third one, you're withdrawing your objection.
What was that?
The third one is and relevant in that they do not exceed the scope of this litigation.
I object to that because relevance has already been determined, and how Mr. Merzero has phrased it is that it improperly allows a third-party witness to decide what is relevant and what is not relevant, whereas my proposed order is quite specific on what he has to produce. The third-party witness does not have the option to assert relevance under ORCP 55.
Mr. Merzero?
Well, Your Honor, I'm the one that's going to be producing these documents, so I'm going to be the one that decides whether a given document is relevant, number one. And number two, I wrote down exactly what the court said at the end of the hearing on the motion to compel, and it was exactly that documents that do not exceed the scope of the litigation need to be produced.
Okay. Is there anything else?
Not from me, Your Honor.
Why is Mr. Merzero producing this? This subpoena is not directed at Mr. Merzero. It's directed at Mr. Jensen.
Do you have anything else from either side?
Not me, Your Honor.
I'm here to discuss. I'm here. What we're here to do is to discuss the objection to the motion to compel, and it is correct that what the limitation is that they may not exceed the scope of this litigation. Otherwise, they are going to be deemed irrelevant. So, is there anything else?
So we have already agreed that the order is. We've already agreed that the subpoena documents were relevant. The order is too vague, and we can't have Mr. Jensen decide what's relevant or not. Mr. Merzero is not the subpoena party, it's Mr. Jensen.
Okay, so I've signed the order, and your objections are noted, Ms. Bong.
All right.
All right, now.
My objection for appellate review. Thank you.
Thank you. Boy, let me find out what else we're here. Why don't we just go through first 25 CV 16784 so that I don't miss anything. I see that there is a motion for protective order. Did we already discuss that?
No, we didn't, Your Honor.
Okay, and is there any objection? Oh, this is the protective order with respect to the motion for the admissions, request for admissions.
Yes.
Go ahead, Mr. Merzero.
Well, it's a simple relevance issue, Your Honor. As you've heard, and as you addressed briefly the last time we were before you, Ms. Bong has raised this issue in every single pleading that she is filing now. And now she's filed another motion to strike, which raises the same issue that she's raised time and time again, which is whether or not I'm allowed to represent my client. And so
hang on a second. I want to be clear about the way that I perceive this, because I think that what I am seeing, and Ms. Bong, I understand you're not an attorney, but this is I don't know what you're trying to accomplish, but just from the outset in 25 CV 16784, this is a case for injunctive and declaratory relief for the production of public records. Does anybody disagree with that?
No, Your Honor.
No.
Okay. And now within this matter for declaratory and injunctive relief, Ms. Bong, you appear to be challenging Mr. Merzeroff's ability to act on behalf of his client. I don't understand where this case has taken the turn for where you can challenge his. First of all, it hasn't even been proven that Douglas County School District 15 has failed to comply. We would have to have a hearing or trial on the merits of the case for a determination of whether or not they've complied with the public records request. But I don't understand how this has now evolved into a avenue to challenge Mr. Merzeroff's ability to represent his client in this particular case.
Under ORS 9.340, it allows the statute allows the adverse party to challenge the authority of the opposing counsel. Mr. Merzeroff has refused repeatedly to produce any documents that he is actually procured under the school's procurement law policy, that he is actually authorized to appear. That goes to the whole issue of whether his filings are even valid in the first place or not. He has made the litigation, especially in the case ending 6-9, very, very, very burdensome and very expensive for both the court as well as me, in order to dispute, over a case that is a $36 fee dispute. In the matter of this case 6784, once again, he has made the litigation very, very burdensome, and it does not appear that he's even authorized to appear in the case at all. So yes, I am challenging his authority to appear.
So when I read ORS 9.340, it says, if it is alleged by a party for whom an attorney appears that the attorney does so without authority, and the allegation is verified by the affidavit of that party, the court may, permissive, if it finds the allegation true, at any stage of the proceedings, relieve the party for whom the attorney has assumed to appear from the consequences of the attorney's acts. So am I reading this correctly to say that it has to be the party that the attorney is appearing on behalf of?
That's correct.
I've currently lost my internet connection, so I can't pull that up, but there are two subsections of that statute. One is for the party who the attorney appears for, and one is for the party, the adverse party. So
I'm looking
I believe the one.
I'm looking at the statute that you cited, and there are no subsections that I'm seeing.
I may have quoted. According to my filing, was 9.340, but I may have misquoted that. Like I said, I don't have any internet connection now to pull up it should be 9.3 something, but I can pull it up right now, unfortunately.
Your Honor, the other issue here is that this is an issue that's already been decided by the court. Ms. Bong filed a motion to strike my pleadings on the basis that I wasn't authorized to represent defendant. I filed an affidavit from the superintendent in response, and the court denied the motion. So it is the law of this case that I am authorized to appear for defendant, and I think everyone should be encouraged to move on.
So I'm just gonna, in fairness to Ms. Bong, in 9.350 says the court or judge thereof may, on motion of either party and on showing reasonable grounds thereof, require the attorney for an adverse party to prove the authority under which the attorney appears, and until the attorney does so, may stay all proceedings by the attorney on behalf of the party for whom the attorney assumes to appear. So I think to a large degree, this is without I don't see what point this is going to address. As Mr. Merzero stated, an agent of the school district, I should say probably the principal agent of the school district, has signed an affidavit authorizing Mr. Merzero's, or confirming Mr. Merzero's representation of the school district.
That is insufficient under the district's procurement documentation requirement, Your Honor.
Okay, so as I said before, any other, and the statute is written permissively. It isn't a shall, it's a may. And any further pleadings to this effect without additional new information for the court to consider are denied. You are not in a position to challenge Mr. Merzero's representation of the school district.
All right, I raised my objections for appellate review, Your Honor.
I understand, and those objections are noted. All right, now on to the motion, the protective order. What's your position, Ms. Bong?
Once, I'm sorry, and I did not prepare for this one because I wasn't aware that we were going to argue against their motion for protective order here.
I believe the protective order is to well, there's a large section of the request that the school district is effectively asking for the court to order that they not be required to respond based on, again, what appears to be your desire to attack Mr. Merzero's representation of the school district in this case. Is that a fair summary of what the protective order is getting at, Mr. Merzero?
Yes, Your Honor, that's exactly right.
Ms. Bong?
My RFAs do not only supposedly attack his authority to appear. It also goes to the case itself. I believe RFAs 27 to 40 something go to admissions for the burden on the respondent to show whether it has complied with public records laws or not.
Mr. Merzero?
Well, she's right, Your Honor, that those RFAs that go beyond number 30 are largely directed at other matters other than my representation of my client. But that leads us to the fact that she's only allowed 30 RFAs, and she chose to spend them on this irrelevant issue. So
is that the first 25?
The first 26 of her 30
First
were
26.
About my representation of my client. And I answered 27, 28, 29, and 30 and objected to 31 plus because she only gets 30.
Ms. Bong?
Well, if he says that 21 to 26 are irrelevant, then the rest are relevant. And if the court is going to disregard the 21 to 26, then the rest of them are part of the number of 30 RFAs.
For a period, I'm looking at number 3. For a period February 1st, 2023 to present, admit that Douglas County School District 15 has no documented findings, justification, or board authorization for any sole source or direct procurement involving Brett Merzero per policy DJCA-AR for state court litigation or public records disputes involving Jill Bong. Now, how does that relate back to what you're suing for, Ms. Bong?
It goes to the defense, Your Honor, whether he is authorized to even appear and defend this case.
Whether what?
whether he's authorized to appear and defend this case. However, Your Honor, as you have already ruled, you do not wish
We've already
to
dealt with that. Yeah.
this issue. So we're just dealing with, I believe, RFA 27 to 40 something.
Okay, so and Mr. Mergereau has responded to 27, 28, 29, and 30, correct?
That's correct.
And Ms. Bong is asking for him to now respond to 31 through 42.
Correct, Your Honor.
Correct. All right. I will. So if I go from 27 to 42, that looks like there's 16 requests. I understand respondent's point, but I am going to allow for the leave to require that 31 through 42 be responded to. And the motion to strike, disqualify, enter, default, and impose sanctions is denied. And was there anything else?
I believe the issue for the case ending 6-9 has a similar leave to increase the RFAs with a similar situation. The first 1 to 26 involving Mr. Mergereau's authority, and the rest.
You are hang on a second. I just want to be clear right here. I'm understanding. You're asking for leave to serve additional in addition to 31 through 42?
No, it would just be 31 to 42, which was already served on the defendant, basically.
Sure, and I've ruled on that. So is there anything else, or is there anything that is outstanding? There's so many filings in these cases that I'm doing my best to keep track of them, but I understand that at times there are things that miss the court's radar, and so I just want to address with both parties to determine, is there anything outstanding or that you're expecting a ruling on that I've not ruled on at this point?
Not from my perspective, Your Honor.
What is that, Ms. Bong?
I don't believe so, Your Honor, not for this case. Other than the other case ending in 6-9, which was also the leave to increase the RFAs, similar issue.
Is it the same request?
The questions are different, but obviously they are tied to the issue of the overcharge of the $36 in that case.
Mr. Mergereau, what is your client's position on that?
It's the exact same in both cases, Your Honor. Our position is, and my argument is she hasn't shown good cause for extending the number of RFAs. Her failure to understand the rules is not good cause, but I understand the court's ruling.
Yeah. Okay. So, Mr. Mergereau, you are prepared the orders to each of the rulings here today. Is there anything else from either side at this time?
I don't believe so, Your Honor.
I do not believe.
Okay. Have a good day.
You as well. Thank you.
Thank you.